Hey, it's Ms Legalista, aka Attorney Sheila. Glad you're here. It looks like Gwyneth Paltrow went skiing, ran into somebody, and now she's getting sued. I haven't checked into all of the details, but I think there's a trial that's getting ready to start. Well, let's get informed before that happens.
Yeah.
I've got the complaint here. We are going to start with that so that we can come up to speed with everything that's been going on. So that the next time you get ready to go skiing, you'll know, hey, here's maybe what I should or shouldn't do so that I don't get sued. This is coming out of the County of Summit, state of Utah. Someone named Terry Sanderson is suing Gwyneth Paltrow, Eric Christensen, Deer Valley Resort Company LLC, and Jane and John Doe, employees 1 and 2. And this is actually an amended complaint. Brief factual summary. This case involves a hit and run ski crash. Remind me to make that the title of this video. At Deer Valley, Utah, where defendant Gwyneth Paltrow skied out of control and hit the back of Terry Sanderson, another skier who was downhill, knocking him down hard, knocking him out, and causing a brain injury, 4 broken ribs, and other serious injuries. Let me just stop right there before we get too much further into this, because initially this may sound like, hey, you're assuming the risk when you decide to go skiing, that other people may possibly run into you and hit you, and you may get hurt. You yourself may get hurt just as skiing, running into something, falling over something, who knows? But there is a risk when you decide that you're going to ski. I've been skiing once. I'm not a cold weather kind of person, so I don't know that that's one of the things that I want to have way up on my list. But here's the thing, these injuries sound very serious. Before I read this case, I was thinking that maybe this was just sort of this thing where it was another person who was looking to take advantage of the fact that they could get some money from a celebrity. I'm just being honest. That is the first thing that came to my mind. Now, as I get into the facts, broken ribs, this sounds like this was a very serious injury. And I'm interested in hearing a little bit more about exactly what went on here. So let's go back. Paltrow got up, turned, and skied away, leaving Sanderson stunned, lying in the snow, seriously injured. A Deer Valley ski instructor who had been training Ms. Paltrow, but who did not see the crash, skied over, saw the injured Sanderson, and skied off, falsely accusing Sanderson of having caused the crash. He also failed to send help, as he was obligated to do, and later filed a false report to protect his client, Ms. Paltrow. Neither Ms. Paltrow nor Deer Valley Lodge personnel notified emergency responders about the injured Dr. Sanderson. They left him at the scene with serious brain injuries caused by Ms. Paltrow. No one from Paltrow's group, including at least 2 Deer Valley employed instructors, bothered to call the ski patrol to assist the severely injured Dr. Sanderson. Later, Deer Valley ski instructor Eric Christensen filled out and signed an incident report falsely stating that Gwyneth Paltrow did not cause the crash, even though Mr. Christensen did not see the crash. These negligent actions by defendants, including Gwyneth Paltrow and Deer Valley, caused Dr. Sanderson additional emotional distress. Okay, as we've stated before, this is coming out of the state of Utah. The amount at issue exceeds $20,000, and it says plaintiffs allege that the value of damages is more than $300,000. The parties: Terry Sanderson resides in Salt Lake County, state of Utah. Gwyneth Paltrow was in Summit County, Utah, and upon information and belief resides in Los Angeles County, state of California. Eric Christensen was employed by defendant Deer Valley Resort Company LLC. Deer Valley Resort Company LLC operates a ski resort in Summit County, state of Utah. And then we have these employees, Jane and John Doe, who are also defendants, and it looks like they are employees of Deer Valley. So here are the general allegations. On or about February 26, 2016, plaintiff Terry Sanderson, although an experienced skier, was skiing at Deer Valley on a green beginner known as Bandana. Now, I did not realize this had occurred so long ago. It is now 7 years later, more than 7 years at this point. Above and behind Dr. Sanderson were defendants Gwyneth Paltrow, Eric Christensen, and Does 1 and 2, along with family and friends of Gwyneth Paltrow. Gwyneth Paltrow was skiing out of control. What does that mean? I don't know what that means. It's a very subjective statement. It would be more interesting, or it would have, for me, it would mean more if he were saying something like, she was almost running into other people. Her arms were wailing as she was. If he had something that was a little bit more descriptive, I don't know what he means when he says she was skiing out of control. It's sort of like imagining a car that's out of control. You say it's out of control. Different people have different definitions of what that would mean. Does that mean the person's running up on the sidewalk, swerving in and out of a lane, slowing up and speeding down, inattentive, looking at their cell phone when you go by? What does that mean, out of control? So in this case, I sort of wish he would have been a little bit more descriptive here in the explanation. Then he says Gwyneth Paltrow was skiing too fast for her ability on a beginner run. Now, it could be that I'm not sure what kind of skier she is. She's on a beginner run, but if you're just starting out, I don't know. Like I said, I've skied one time, and it's easy to find yourself going downhill at a pace faster than you want to go. Paragraph 15, Gwyneth Paltrow was distracted. By what? I'm just wondering. By what? How do you know she was distracted? Was she talking to someone else? Was she fumbling around with her coat? Again, for me as an attorney, just reading this, I wish there was more information in here than just these words that could mean anything to anyone. I need more facts. I mean, this was labeled general allegations. I'm thinking there are going to be some facts in here. I get it. Upon information and belief, Gwyneth Paltrow was skiing in a group of skiers, including family, friends, and Deer Valley employees that were skiing to the bottom of the hill to meet others for lunch at the Montage Lodge at Deer Valley. Maybe she was distracted by family. Upon information and belief, Deer Valley employees, including defendants Christian, Doe 1, and possibly Doe 2, were instructing and guiding Gwyneth Paltrow and her family and her friends in a group while they skied down the ski slope. Gwyneth Paltrow, Deer Valley, and its employees, including, without limitation, defendants Christensen, Doe 1 and Doe 2, owed a duty to other skiers, especially downhill skiers, such as Dr. Sanderson, to ski safely, in control, while maintaining a lookout for other skiers. Of course, we would expect that. These duties were especially important as the party came to the part of the hill where the Bandana Trail was located. Okay, I would like to know why we're saying it's especially important there, but why? Was there something going on at this trail? Was there a convergence of people? I don't know. Was it somehow a little bit more dangerous? I wish this just had a little bit more information in here. Maybe it's coming. All defendants owed a duty to Dr. Sanderson to notify ski patrol or other emergency responders about the crash that left Sanderson injured on the slope, regardless of the cause. Gwyneth Paltrow knew it was wrong to ski out of control too fast for her ability and distracted, but she did it anyway. Gwyneth Paltrow knew that a downhill skier almost always has the right of way, and Sanderson was downhill from Paltrow when she approached Sanderson. Gwyneth Paltrow knew it was wrong to slam into Dr. Sanderson's back, knocking him down, landing on top of him, knocking him out, and then leave the scene of the ski crash she caused, but she did it anyway. Eric Christensen, a Deer Valley ski instructor, knew it was wrong to scream at Dr. Sanderson after he was knocked down and injured by Gwyneth Paltrow, but he did it anyway. It would be nice also here to include what was being screamed. What did he say? That would be helpful too. Eric Christensen and other Deer Valley employees, including Does 1 and 2, who witnessed some or all of the ski crash, knew it was wrong to ski away from Dr. Sanderson after he was hit and injured by Gwyneth Paltrow and not call for ski patrol or other emergency responders, but they did it anyway. It would seem to me that they would have a protocol to follow. I can imagine sometimes that it's not clear when someone falls whether or not you need to call for medical assistance or not, but it seems like you would check. These activities by defendants would have been inappropriate regardless of whether Paltrow was the uphill or downhill skier. Defendants never should have left an injured person on the hill without assistance. So it sounds like they're saying they even if they did not see the crash, that once they saw him there laying there, that they could have at least lying there, they could have at least said, hey, can I help you up? Do you need some help? Are you okay? It sounds like Dr. Sanderson is saying, no, they just yelled at me. But it would be interesting to know, what did they yell and why did he think they were yelling that? It would be helpful to know a little bit more there. Eric Christensen knew it was wrong to falsely report on an official incident report that Gwyneth Paltrow did not cause the ski crash that he did not see, but he did it anyway. Defendants Eric Christensen, Doe 1 and Doe 2, and the employees and agents of Deer Valley and Gwyneth Paltrow, who were skiing with her on or about February 26, 2016, were acting within the course and scope of their employment, and Deer Valley and Gwyneth Paltrow are vicariously liable for their actions as alleged herein. Well, let me go back for a second. This report, okay, I'm hoping this report is attached, and it may have been attached with the first version of the complaint. This is an amended version, so it may or may not be included here. I hope it is. Paragraph 29, Deer Valley and its employees knew it was wrong to cover up in incident reports, and in other ways the true circumstances of this ski crash caused by Gwyneth Paltrow, but they did it anyway. As a direct and proximate result of defendant's negligence, and these are elements now, they're trying to make sure that they're putting all the elements in there for negligence, saying she had a duty of care, she was the direct and proximate cause of this accident, it was a result of her negligence. These are all elements that they are putting in here because they have to show that in order to make this claim for negligence. Plaintiffs suffered physical and mental injuries, including permanent traumatic brain injury, 4 broken ribs, pain, suffering, loss of enjoyment of life, emotional distress, and disfigurement. And this sounds, like I said, way worse than what I initially thought. I thought this was just a situation where 2 people had sort of crashed into each other on a slope, but it sounds like this person has received some serious injuries here, all of which I presume will be supported with evidence at trial. And plaintiff will continue to suffer injuries and damages in the future due to the negligence of defendants. As a direct and proximate result of defendants' negligence, plaintiff incurred medical expenses and additional life care expenses due to injuries caused by defendants. Plaintiff will incur additional expenses, losses, and economic and non-economic damages in the future due to the negligence of defendants. Okay, so first action here is negligence, and this is against Gwyneth Paltrow. Okay, let's go through these elements. Defendant Gwyneth Paltrow had a duty to ski safely, but she negligently breached that duty. Okay, she had a duty. She breached the duty by skiing unsafely, striking a downhill skier, plaintiff, in the back, knocking him down, landing on top of him, and causing him to suffer a concussion. Okay, so there was the result, brain injury and 4 broken ribs. As a direct and proximate cause of Gwyneth Paltrow's breach of her duties of care, Plaintiff has suffered and will continue to suffer damages, including economic and non-economic damages related to the ski crash. So he's listed all of his elements there of negligence. Then you have second cause of action, negligent infliction of emotional distress, all defendants, because the other defendants really weren't the ones who ran into him. So it's hard to claim that they were negligent in some sort of way. Paragraph 35, plaintiff realleges everything. Paragraph 36, defendants Gwyneth Paltrow, Deer Valley, Eric Christensen, Doe 1 and Doe 2 neglectfully caused emotional distress to plaintiff. These defendants should have realized that ignoring, denying assistance to, and skiing away from plaintiff after Paltrow struck and injured plaintiff in a ski crash would cause plaintiff emotional distress in addition to the physical injuries he suffered in the crash. These defendants realized and or should have realized that hitting and running away after Paltrow struck and injured plaintiff, leaving him alone and later denying or covering up the fact that Paltrow caused the crash would distress plaintiff and cause him illness and bodily harm. Shortly after the crash, plaintiff asked the Deer Valley employees what had happened, what records Deer Valley had, and what Deer Valley was doing to investigate the crash. Deer Valley produced false information to plaintiff, indicating that Paltrow did not cause the ski crash that injured plaintiff as described above. This false information, along with the false accusation of Eric Christensen right after the crash when he screamed at plaintiff, "What did you do?" Now we know what he said, caused plaintiff to suffer severe distress, resulting in mental and physical harm to plaintiff, including anxiety, depression, and other health problems. Now, let me stop there for just a second, because I asked when I read the part where it said he screamed at him, what were the words that he screamed at him? And now he is saying what it was. What did you do? He is saying that caused him severe distress, resulting in mental and physical harm. Someone screaming at you, what did you do? From my personal opinion, this is just my personal opinion, that's really not enough. Let's just be honest here. How many people are going to, a lot of people get upset when screamed at. If we were all running to the courthouse every time somebody screamed at us after an accident and suffering, that's probably not enough. Okay. What he is saying here, though, is when you tie that in to being left there and he's feeling bad, trying to reach out to them to figure out what's going on and receiving what looks like a false report, that all of these things together are causing him emotional distress. Now, that I think has a little bit more substance to it. But in and of itself, somebody screaming at me, yes, people have screamed at me in my lifetime for all kinds of things. So in and of itself, I'm feeling that's a little lightweight. Along with some other things, if you can make a case for it, you've got to have some facts to substantiate this and actually make it look like it rises to the level that someone would reasonably think, oh, yes, I would totally have been upset too. I would have been upset for days after that. If people can feel that way about the scenario that you're explaining happened, then you might be able to get somewhere on this claim of negligent infliction of emotional distress. Last paragraph in this section, as a direct and proximate result of these defendants' breach of their duties of care, plaintiff has suffered and continues to suffer damages, including economic and non-economic damages related to the negligent infliction of emotional distress by defendants on plaintiff. Request for relief. So what is he asking for? For non-economic damages in the amount to be proven at trial. Okay, listen to what he's got listed here. He talks about disfigurement. And again, this is just the complaint. At trial, he's going to have to present evidence about this disfigurement. He's going to have to present evidence about loss of enjoyment of life. Here's the thing. If you're someone like Gwyneth Paltrow, and Deer Valley, then you hire a private investigator. You check out what they're doing on social media. You have them followed to see if there really is this loss of enjoyment of life. Is this person attending birthday parties? Is this person going to regular physical workouts? What does this person's daily life look like? Do you see them out and about in the world smiling? I hope that over the past 5 years, this person has been mindful of the fact that someone could be watching everything you're doing. You're saying that you've lost enjoyment of life, but your daily activities, if captured on video or on film, could look very different, especially if we say, take a person who has a social media account like Facebook, and you're able to go up there and see that the person would sometimes post pictures of walking with his wife and his dog 3 times a week. And now, 2023, you see posts that show him still walking with his dog 2 or 3 times a week and other activities. Now, the person might be able to say, yes, I can still do that. But because of the accident, I have to take aspirin or Tylenol or ibuprofen before I go for that walk. And after that walk, what you don't see is the fact that I need to rest, or that I take a hot shower and massage my muscles afterward. So this can go both ways. A person outside looking into your life to see if you really have this loss of enjoyment. And then you on the other side saying, well, yes, but that doesn't tell the whole story. So let me tell you what the story really looks like. It'll be interesting to see how exactly this plays out and to what extent their attorneys are going to dig deeply into the claims that Mr. Sanderson is making here. He is also asking for future medical expenses, life care expenses, out of pocket expenses, and other damages allowed by law. He's also asking for prejudgment interest on the damages, punitive damages as allowed by law. And I think what he's going to be arguing is that they left me there and that there should be some punishment for this false report. Now, sometimes what's labeled a false report can generally just be we had a different perception or perspective about what was happening there. She may get up there and testify that, hey, he was not in this spot standing still. As a matter of fact, he was skiing himself and he was reckless about what he was doing. And therefore, I could not adequately go around him because it was hard to anticipate what he was doing. I haven't seen her counterclaim. I think I read somewhere that she may have filed a counterclaim. Maybe some of this is in that. I will look and see. And if so, I will do another video on that as all of these emails are popping up on my phone. So this punitive damages piece, he may be using this false report or something he's labeling as a false report to claim punitive damages. And then, of course, attorney's fees. And this was dated February 2019. So the accident happened in 2016. This amended complaint, it looks like, was filed in 2019. And I will take a look to see if there is a counterclaim by Gwyneth Paltrow. It is currently March 2023. It's expected that this trial is going to be starting fairly soon. We will see how it goes. Don't forget to like the video and subscribe to the channel so that you can stay up to speed with, hey, what you should do if you're out skiing and you run into someone so that you don't get sued.